for partnering with the state of California to protect these lands. Today, our team is going to walk you through the department's easement acquisition process and discuss the updated grant agreement, which has been tailored to the SALC program in order to provide you with more clarity on the requirements and to help you move your easement through the process. Please hold your questions until the end of the presentation.
Okay, so the first slide here shows the major steps in processing, in the process of executing the grant agreement. The process begins with the DOC grant manager customizing the grant agreement template for your project. Customization includes identifying the property, preparing the budget, which is pulled from the grant application, and preparing the implementation schedule. Once the draft is completed, it will be emailed to the grantee for review. And once the grantee review and approves the draft, the grant manager will send it through its first internal review within the department. This will take about 2 to 4 weeks. And 2 copies of the grant agreement are then mailed out to the grantee for signatures. The grantee will then mail both of the signed grant agreements back to the grant manager, who will then initiate the second and final internal routing. The DOC director will then sign both copies. DOC will scan the signed agreement and will provide you with both a digital and original hard copy of the fully executed grant agreement. Since the prior round of funding, DOC has worked on updating and improving the DOC grant agreement template. Highlights include removing the often lengthy legal description and instead relying solely upon a plat map. Completed appraisals are no longer required to be submitted within 5 months of the start date of the grant agreement. That requirement has been removed, so there is not a specific deadline other than a general target date within the implementation schedule. The practice of requesting draft invoices for the grant manager's review prior to formally signing and submittal has now been included as a requirement. This provides the grant manager and grantee with an opportunity to identify and resolve any issues before receiving the formal invoice. Grant managers will also prepare a customized invoice template that will be provided to the grantee for use. And the implementation schedule has been reformatted and fleshed out to include greater detail. We hope that this new format will make the schedule more useful over the life of the project, and maybe even turning it into a sort of living work plan that the grantee and the grant manager can together keep up to date and use to track progress. I think there's on the next slide, there's a visual of that. No significant changes were made to what was formerly called the scope of work, which is now entitled Conditions of Funding Dispersal. The grant term will be, so these are some points to remember. So the grant term will be 2 years, although we hope to close most projects within a year or so. The terms and conditions of the grant agreement are considered non-negotiable. However, the exhibits will be customized for each project. The soonest we could receive and process the first invoice is at least 3 weeks after the Department of Conservation Director signs the grant agreement. And each grantee will need to provide an updated payee data record form, which ensures that your organization is in our state system. Your grant manager will provide this form to you in the near future. The image at the right shows the updated format of the implementation schedule. And you'll see it includes greater detail and completion time frames, target dates, responsibilities, etc. Some additional points to remember, specific to budgeting and invoicing. The grant agreement will allocate a portion of the grant award to associated costs and a portion to associated costs. Did I say? So a portion to acquisition costs and a portion to associated costs, such as staff time, appraisal, title, etc. These figures will be pulled from the grant application. Funds cannot be shifted between these two separate categories. If you wish to shift funds within the associated cost portion of the budget, such as shifting funds from the appraisal line item to the staff consultants line item, you will need prior DOC approval. You can submit that request to your grant manager. If in your grant application you requested funding for a survey, environmental site assessment, and or a mineral remoteness evaluation, your grant manager will be requesting justification for DOC review and approval. When you receive your draft grant agreement, please confirm that the hourly pay rates are accurate and adequate for the 2-year grant term. DOC will not approve increases to staff or consultant pay rates captured in the grant agreement. Certain associated costs incurred after submittal of your grant application may be eligible for reimbursement. Reimbursement would be sought through the second invoice after the project closes. If requested in your grant application, DOC can pay for one appraisal. If multiple appraisals are needed for the project, DOC will pay for the DGS, which is Department of General Services approved appraisal that establishes the final ACE or the final easement value. And if your project includes multiple easements, in the budget portion of the grant agreement, your grant manager will list each individual easement with a breakdown of costs. And some additional points. So before I leave the topic of the grant agreement, please remember that you'll receive 2 hard copies of the grant agreement to sign. You'll sign both copies and return both copies back to the grant manager, who will then submit the agreements for final DOC signatures. Also keep in mind that the individual that signs the grant agreement on behalf of the land trust will also need to sign the invoices. If you need someone else to have the authority to sign invoices, then you will need to provide a letter designating that signature authority to a specific individual. And this letter will need to be submitted to the grant manager. Lastly, the official start date of the grant agreement is the latest signature date of the parties, which will be the DOC director. So now transitioning to public notification and specifically to neighboring landowner notification. At this point, you've already completed certain public notification requirements, such as notice to the local government and publication in a local newspaper. The remaining steps include neighboring landowner notification and the local government resolution of support. For the neighboring landowner notification, that requires noticing adjacent landowners for the proposed acquisition. Only one letter is needed for those adjacent landowners that may own multiple adjacent parcels. This letter must be mailed and sent at least 30 days prior to the Board of Supervisors meeting to consider the resolution of support for the project. It doesn't need to be mailed exactly 30 days prior, just at least 30 days prior. To provide DOC evidence of having completed this requirement, please provide the grant manager with a copy of the letter, the date the letter was mailed, a list of the names and APNs of those on the mailing list. The information that we would like to see in the landowner letter includes a statement regarding the grantee's intent to purchase an easement, the proposed easement's acreage, APNs of the addressee's parcel adjacent to the proposed easement, proposed funders, including the SALC program, statement regarding the perpetual nature of the easements, who will hold and monitor the easements, statement regarding your nonprofit status, if applicable, map or parcel map outlining the proposed easement area, and your contact information. Regarding the resolution of support, the final public noticing requirements, this is the final public noticing requirement. This can be passed at any time following the 30-day adjacent landowner notification that I mentioned earlier. Although technically the resolution needs to be passed and submitted to DOC at some point prior to the close of escrow, we suggest working on obtaining this resolution as soon as possible. That way you don't have to worry about it later when the workload intensifies and critical deadlines start to loom. The resolution of support has unnecessarily held up more than a few projects over the years. So again, we encourage you to start working on that as soon as you can. The resolution should refer to the SALC program and identify the property proposed for acquisition, such as APNs, acreage, and location. The Board of Supervisors should approve the proposed acquisition and certify that it meets the following SALC eligibility criteria relating to ag viability, the general plan's commitment to ag conservation, and conversion threats. Sample templates for landowner notice and for the landowner notice and the Board of Supervisors resolution of support will be made available on the SALC website. And next, Shauna Atherton will talk about the easement transaction.
Thank you, Tim. So once you're in a grant agreement, your grant manager will work with you to finalize all required project documents associated with your easement transaction, from the appraisal review to closing. While you are likely to be working on various aspects of your project at any given time, this slide provides you with a general idea of when DOC anticipates specific tasks within the easement acquisition process to occur, and more specifically, when you should involve the department in those tasks. Most importantly, please keep in mind that working with the department is an iterative process. We will likely return any document we receive back to you with feedback. For example, we typically see up to 5 versions of easement language before we approve the final document, more if there are significant changes in reserved rights or if multiple match funders are involved. While we will work to return documents to you in a timely fashion, items that require additional review may take longer than the time shown on this slide. If you have questions about a document status, do not hesitate to reach out to your grant manager. Per the SALC guidelines, the final easement value will be based off of a qualified appraisal. The appraisal used must be approved by DGS and the department, must meet DGS appraisal specifications and comply with the department overview and preparation of appraisals, must list the Department of Conservation and DGS as intended users, and must include reserved rights consistent with those in the approved easement, as well as a copy of the draft easement, particularly the required SALC terms. We may require an update to the appraisal if the effective date is over a year prior to the close of escrow, or if the easement terms or reserved rights assessed in the appraisal differ substantially from those listed in the final approved easement. Please keep in mind that we will only pay for the appraisal used as the basis of the easement value, and we will not pay for appraisal updates. This is particularly important when you time the commissioning of your appraisal. So regarding title, the department's title review begins in the application stage and continues throughout the project's life. Your grant manager will work with you to determine which title exceptions will need to be removed prior to close of escrow. If the preliminary title report that you submitted with your application is over a year old, or if you have resolved specific title concerns between the application and now, please submit an updated report at your earliest convenience so that we can reassess whether any concerns remain or any additional concerns have surfaced. Please keep in mind that when we request a PTR, we are also requesting all underlying documents associated with that report. These documents are most easily submitted as hyperlinks within the PTR itself. If the title report is not hyperlinked, you will need to email us copies of all of the underlying documents. Delays in submitting your underlying documents for a project may result in delays in the department's project review. The department reserves the right to withhold funding until all title issues are addressed to our satisfaction. Title concerns we typically flag include, but are not limited to, separated mineral rights, legal access, and other third-party interests. Title concerns that can be addressed through subordination include leases and deeds of trust. All subordination documents are subject to the department's review and must be approved by DOC prior to the close of escrow. Deeds of trust may also be paid off in full. So if your landowner decides to pay off their deed of trust in escrow, you will need to include the reconveyance within your escrow instructions. DOC will also need to review and approve a pro forma title insurance policy for the easement prior to close of escrow. The pro forma must only include those title exceptions accepted by DOC. It should list the department as additional insured and provide insurance for the full appraised value of the easement. The approved version of the pro forma will be referenced in the escrow instructions, so please have the title company date each version for easy reference so we know which version we're using as the final. So your easement negotiations. The department has approval authority of the final easement resulting from each SALC grant. As such, you should include the department in your easement negotiations early on in the process to avoid delays later on as deadlines loom. The SALC team has updated its easement template and developed a checklist of required easement terms for your use. Use of the easement template in its entirety will expedite the department's review of your easement. If you choose to use a different easement as a base, please refer to the checklist for a list of items required for inclusion by SALC, including those clauses and statements that should be integrated verbatim. Both the easement template and the checklist will be made available on the department's website soon. Most projects will include a number of rights reserved by the landowner. The reserved rights included in the easement and assessed by the appraiser should be consistent with those outlined in the project application. Any changes in reserved rights should, where possible, be requested prior to completion of the appraisal to avoid the need for an appraisal update. As always, all reserved rights are subject to the department's review and approval. Any changes that would substantially alter the project or that could affect the project's eligibility or competitiveness will be denied. Failure to integrate SALC's required easement terms or to consult with the department on reserved rights early in the easement negotiation process may result in delays to your project's closing. We want to remind grantees about our program's current policy on restrictions on agricultural use. If a property is currently in irrigated agriculture, no restrictions on agricultural use will be allowed on the irrigated agricultural acreage. If a property is in grazing, restrictions on agricultural uses will only be allowed if required by the match funder. So please be sure to consult with your grant manager if you have questions. DOC will work to move your project toward closing as efficiently as possible. However, certain factors may lengthen our review, including not using the SALC easement template or checklist, integration of match funder requirements, changes in reserved rights, changes in acreage or boundaries, or significant formatting issues. On the topic of formatting, in order to ensure that all parties are working on the most recent version of the document, we ask that you rename your easement document in a logical way prior to each resubmission to the department for review. We understand that most grantees receive feedback from multiple parties, so how you rename the document is up to you. Some grantees choose the most recent revision date or a new version or draft number. So long as you're consistent, that's what matters. Please note that if the document is not renamed or if the length of the document becomes too long, department staff will rename the document for ease of tracking within our system. Within the file itself, please include the version number and date of last revision in the footer of each version. Also, be sure to turn on line numbering and have the line numbers restart on each page. All changes between each version should be provided in red line or track changes. If the department has noted that it is still reviewing specific language in a version returned to the grantee, please leave that language and track changes in each subsequent version until the department has indicated whether the language has been accepted or rejected. If the department does not comment on language and track changes and those changes are amenable to the other parties to the easement, those changes can be accepted in the next draft sent to DOC for review. Substantial formatting issues can cause significant delays to the department's review of your easement. For this reason, we will now return documents with substantial formatting issues to you for correction without reviewing the document first. So please address any formatting issues prior to returning your easement document to the department for review. Map exhibits included in your easement should be readable in black and white. They should have simple features that are easy to scan as well as record. Be sure to use various line weights and symbology to show contrast between features. For example, solid and dash lines or polygons with gray fill and cross-hatching. Shaded polygons can be used to call attention to natural features on the landscape, public lands, adjacent easements, or other areas. All maps should include the easement boundary and key features such as APNs, creeks, roads, water infrastructure, and jurisdictional boundaries. If feasible for the scale of the map, infrastructure features such as fences, wells, pumps, towers, solar arrays, or other features should be identified with the symbol on the map or a text label. All map exhibits should include a north arrow and a scale bar, as well as a basic legend with data source notes. The location of both existing building envelopes and future building envelopes should be shown on the building envelope and existing improvements map, which is typically Exhibit C, along with acreages for the related envelopes on either the map or in the legend. Color graphics, complex patterns, and aerial photos are best saved for use in the baseline documentation report. And with that, I will hand off the presentation to Michael, who will help bring your easement to a close.
Thank you, Shauna. So after the easement has been negotiated and finalized, the next steps will be to complete the baseline conditions report. The SALC team has created a checklist that shows the minimum standards of what should be included in the baseline report. This checklist will be available on the department's webpage shortly. Once this checklist has been finalized and uploaded to the website, grant managers will notify the grantees. So once the appraisal, easement, and baseline are near the final draft and all title issues have been resolved, meaning there's a clear plan to address and remove all issues from the title policy report, it will be time to begin drafting the escrow instructions. In most cases, the grantee will provide the department with the draft buyer and seller escrow instructions, and the department will be added for combined joint escrow instructions. It is important to note that prior to submitting the escrow instructions to the escrow officer, the department must review the draft to ensure all the following items are included: subordination of all liens and financial encumbrances, recordation of the easement immediately following the close of escrow, issuance of title insurance with the department listed as additional insured, provisions of all relevant documents to the department within 30 days of closing, and provisions that state, should the easement not be conveyed, SALC funds will be returned to the department. Please note that before the department can release the warrant into escrow, the department must be provided with the escrow officer's signature on these escrow instructions. For the acquisition invoicing, once the grant managers determine the project is near completion, meaning the easement, baseline, and appraisal have been finalized, the grant manager will provide the grantee with a customized invoice acquisition template. The template will include the approved portion amount funded by SALC, match funding amount, the project's grant number, and the invoice number. This will be the first invoice unless there are multiple easements, in which case they should be numbered sequentially. The grantee will then review the invoice and check for accuracy and submit the invoice on the organization's official letterhead. The invoice must be signed by the authorized signatory or authorized designee as stated in the grant agreement. Please note, digital signatures on the invoices are now acceptable by the department. However, if you choose to submit a hard copy, the invoice must be signed in blue ink. So for the next topic, we will discuss the tasks and requirements to be completed once the easement has been recorded. So once the easement has been signed and recorded, the following must be submitted to the department within 30 days. A conformed copy of the recorded easement and subordination agreements, if there are any, a copy of the title insurance policy, the final baseline conditions report that is unbound, signed and received, both hard copy and digital copy, the final closing escrow statement, and the final report. Also, the associated cost invoice. Please note the associated cost invoice will only be paid once all of the deliverables listed on this slide have been received and are approved by the department. The associated cost invoice and supporting documentation are much more detailed than the acquisition invoice. After the easement is closed, the grant manager will once again provide a customized invoice template. Please note, associated costs will only be paid after the easement has been recorded. Because the associated cost invoice can be so complex, the grantee must submit a draft invoice with all the supporting documents prior to submitting the signed invoice. Most invoices will go back and forth a couple of times between the grant manager and the grantee to ensure all documentation and information is correct. Like the easement acquisition invoice, the department must receive an original signed invoice in blue ink along with 2 copies of the signature and 3 copies of all supporting documentation. If there are any changes to any of the associated cost line items, the grantee must submit a budget change request in writing prior to the submission of the draft invoice. So the associated costs will only be paid once after the easement has recorded. Once the items listed in the budget on the grant agreement will be eligible for reimbursement. The department will only pay for cumulative associated costs up to the amount approved by the Strategic Growth Council. Line item activities in the invoice should correspond exactly to those listed in the budget. It is also important to note that the department will not pay above staff and/or subcontractor rates listed in the grant agreement. All supporting documentation for SALC reimbursement must be provided. example of the documentation that must be submitted with the invoice is listed on the right. Supporting documentation for matching funds does not need to be submitted, but should be retained by the grantee in the event of an audit. If the grantee chooses to publicize the easement project after the easement has closed, it is recommended that the grantee coordinate the press release with the department. The department will review the draft press release and ensure that the grantee has included the following information: the roles that the Department and Strategic Growth Council have played in the easement project. The grantee must name California Climate Investments as the funding source and include the California Climate Investments logo in the publication. Please note that the California Climate Investments logo must comply with the usage guidelines. The usage guidelines can be found on the California Climate Investments webpage. The grantee must also include the email address on the distribution list, as well as post at CA Climate Investments Twitter link on web pages that are related to the project. So once the easement is closed, annual monitoring of the easement property by the easement holder will be necessary to ensure compliance with the terms of the easement. The annual monitoring report should describe the following items: current land use, any transfer of interest within the last 12 months, any construction or restoration or plans to change the land use in the next year, any subsequent easements placed on the property, and any potential easement violations. Monitoring reports are available online and should be submitted no later than June 30th of each year. For example, if the monitoring was conducted in the fall, then the monitoring report would be due by the end of June the following year.
So that concludes our presentation. We'll now open up the forum to questions. If you have a question, please send it to us via the chat function and we'll respond to your questions in the order they're received. If you're on the phone, then we will address your questions after we get through the chat questions.
Okay, so our first question that we've received is, can the landowner notification occur prior to signing the grant agreement? And the answer is yes. The public notice items that are still due can be received at any point between now and prior to the easement closing. Another question is, are these slides going to be available for download? We are video recording this, and the entire video will be made available online. It will take us between 1 to 2 weeks to get that posted, but that will be available to you, yes. Has the list of easement language requirements been posted on the department website yet? And if so, where? So that document is undergoing its final review, so it has not yet been posted. We should have that up in a week or two. Would we be able to post the slides above without the video presentation? I don't see why not. That will also take us about a week or so to get prepared. Will the department have a template for the press release requirements? So is that referring to, that's not referring to the public notice. That's any document that you would publish in a newspaper. We don't have a template for the press release. We have language that California Climate Investments requires be included, so we can provide that language to you. However, we do still ask that you submit any press releases to us for review.
So the next question, a little lengthy, I'll read it. It says, what happens if the final appraised value is different from the value on which the grant agreement is based? If higher, presumably grantee is responsible for coming up with the difference. Question, if lower, can the difference be applied to transaction costs if none were requested initially? So first question, if the value comes in higher than what is shown in the grant agreement, yes, we can't, the amount that is approved by SGC is a not to exceed amount, so we could not increase that contribution towards the easement. If there is if the value comes in lower and there's some money there that's presumably not needed for the easement acquisition, we would not be able to shift that money to cover any associated costs. As stated earlier, we can't move between those two categories.
Do you require a legal description of all building envelopes and/or special land use zones?
Well, I'll say that it's probably a case-by-case basis, depending on the nature of the building envelope. If it's one that would suggest, if it's complicated, floating in the middle of the property somewhere, we'd probably treat that on a case-by-case basis. If it's a pretty straightforward envelope, a square in the corner of a property, in those cases, I wouldn't imagine it'd be overkill to need a legal description. But I think the answer would be it'd probably not, but we deal with it on a case-by-case basis. The same would go for special land use zones, which is not something that's a little less common, but again, it'd be probably on a case-by-case basis to see if if a survey is needed, then we can cross that bridge when we get there. But I think generally, we probably would not need a legal description for those items. Next one, it says, is the letter of notification template that you previously provided consistent with the requirements you noted today? It's a letter of notification template. Yeah, I think it should be consistent with. So I guess we have an existing template, and you're asking if these, they are consistent. I don't think there's anything notably different on those two.
I don't think so. I believe we're revising the intro to the template from CFCP requirements to SALC requirements, but the letter template itself should be consistent with the terms.
I'll read the next one here. There's a question that says, or asks, are the neighbor notification and county resolution different now from what was in the original grant guidelines? If we already did this, do we need to do it again, indicating the grant was awarded for acquisition? I'm not sure I fully understand the question, but
I believe I know who that's coming from, and the answer is no. If you've already done your public notification requirements and you did them prior to submitting the application, what you've submitted is sufficient. Related to the question of legal description for building envelopes, would a legal survey of a building envelope be required? So again, it's likely a case-by-case basis. If it's a building envelope that's tied to a road on the edge of the property, probably less likely that it will be required. If it's floating in the center of the property, we would have to look at the characteristics before coming to a determination on that. I will say that we appreciate GPS coordinates for corners, and tying at least one corner of your building envelope to a permanent feature on the landscape is much appreciated. Hopefully that provides some clarification. All right, I'm actually going to unmute our folks on the phone in case you guys have any questions. All right, it looks like we don't have any other questions, so we're going to wrap up. Virginia?
Thank you, everybody, for attending our webinar. If you have further questions, please feel free to contact the department or your grant manager. and we'll get back to you as soon as we can. So thank you very much.